Now we are asking for an order that the judge recuses himself from further hearing this case. And the ground is that in the course of his judgment, at the close of the case, he gave a written judgment, which is a lengthy one actually. How many pages is it?
60 or 65.
65 pages. Now we find that the judge has made some findings which are conclusive. For example, he says, I find the accused a witness of truth, that he is a truthful witness and so forth. And he ought not to have said that, because that ought to be reserved until the end of the case. In other words, after defense is called, then he must make findings as to who is telling the truth. Not at the stage, where defense is called. So our argument is that, having regard to that, he has prejudged. There's a prejudgment on his part, virtually nullifying the calling of the defense, because he's made up his mind. And that prejudgment amounts to bias. And that being the position, we want him to step down from further hearing the case, and we want a new trial, because fair trial is, under the circumstances, not shown by the learned judge. And
the defense has been rendered nugatory as a result of the prejudgment.
You see, under the law, that's section 182A1. It's only at the close of the defense, end of the trial, in other words, then the judge must, consider all the evidence. Consider all the evidence to decide whether the case has been proven beyond reasonable doubt. So it's at that stage, not at the close of the case for the prosecution. At that stage, all is required to do is to find out whether there is a prima facie case made out. And a prima facie case is made out, then he calls for the defense, without going into questions of truth, for example. Whether the witness is telling the truth is something which has to be deferred until after all the evidence has been heard. So that's what it is in the application we are making. And we want this application to be heard on Monday itself, before the continuation of the trial. And from there we will see what are the steps to take depending on what the judge decides. We want the trial to be started de novo. De novo. In other words, a new trial altogether, with a new judge sitting this time. Well, unfortunately, we have had, I think, not more than how many witnesses have they called so far? Five out of the 25. You would have expected the Prime Minister by now, together with his wife, to have been brought to court so that we could, interview them.
So what are the progress? Are they giving any indication to be interviewed?
Some of them have been reluctant.
No, it is, I think, for the Superintendent Jude, the investigating officer, to make the arrangements. Whether the witness likes it or not, he has to come here for the purpose of our interviewing him, to decide whether we want to call him. And that's the order by the judge.
Apparently, the former IGP and
Road one. They did not come.
They didn't come.
Yes, they did not show up. And I think that's contemptuous. One, I think, more importantly, to disqualify the judge. I think that has to take priority. That's the main one. The rest does not arise. Because if he is disqualified, the question of whether they have produced witnesses for our for us to interview them doesn't arise. First things first, I think, and this would be what we would want heard first. The crucial witnesses are the ones we would want to interview, and we have indicated to them.
Any reasons for not turning up, or
no reasons are given. I think, like in the case of Musa and Rudwan, I think even the officer who arranged it didn't turn up, isn't it?
Yeah. See, we arranged that on the 16th that we all had the court premise here, and everything, and the arrangement is every day at 5 o'clock or 5:30. So that's why we always here. I mean, that's what it's all about. So we came here, and the police officer, including the two witnesses, didn't turn up. In terms of Musa Hassan and Rodwan. As to the PM and the wife, no arrangements has been made, I've been told. On the 18th, on the 16th itself, we asked for a copy of the judgment because Dato' Sri has given us the instruction already. But we didn't get. Then when we called the judge's office, they said write in. So on the 18th of May, we wrote in asking for a copy of the judgment. It wasn't given. Then we actually gave notice to the judge on the 24th of, a week later, on the 25th of May, saying that we intend to file an application to recuse your lordship. Kindly let's have the CTC copy because that's procedure. We need a CTC of the copy. And it wasn't given. Then I sent a reminder on the 30th again. Where is my copy, or when can I get it? And only on the 30th, there was a phone call and we went and collected it. And today we are filing it. So that's the reason. There's no plan to delay anything or a last minute filing. It was there all along. From the 16th itself, instruction was given. But we had procedure to follow.
It's no question of abuse of process. We must make it very clear.
Yes.
Dato' Sri is just exercising his legal right. And he has the right at any point to make an application if the situation warrants it, that the judge ought to recuse, and we find this is a proper occasion when it has to be done.